All right, I think we're good. Hello. So welcome to those joining us this, what is an early morning in London. Today, over 90 minutes, we're going to critique the investment treaty regime. Hi, thanks, Marcus. As moderator, I'm going to begin by posing a question to each of our speakers. Each speaker will respond, and then I will invite the rest of the panel to reflect on the question asked. We'll do 2 rounds of that, and in the second round, I'm going to invite our listeners to offer their own comments and questions. So each speaker really targets a different problem with the investment treaty regime. It ranges from a concern with the ongoing legitimacy of investment treaty arbitration to pulling at the roots of the regime itself, potentially just scrapping it and starting over. The spectrum of critique within our scholarly community is clearly broad. As such, the problems that we see with the regime are quite multifaceted rather than simply hierarchical. By that, I mean, that we have to attack one problem to get to the next. So, for example, the concerns that Federico raises in his paper may not even touch upon the problems that Mavluda is dealing with. The implication is that we all must strive to understand the soul of the regime, that which keeps this growing network of treaties and laws together and working, despite the skepticism some of us within the scholarly community have with keeping it going all together. So my hope is that as we break apart the facets of our critique, we do 2 things. First, we state our research agendas and what our end goals are, a clearer approach to consideration of public interests when protecting investors' investments, or designing foreign investment laws that prioritize distributive effects of foreign investment. Second, we need to unpack our methodological choices. Sometimes in law, we avoid these discussions, but we have to be aware of our methods because this influences our object of study and then our prescriptions for that object. So especially in the investment treaty regime, this is all the more important where our subject is quite political. So now I'm going to begin. I'm going to introduce our first participant in this session. It's Professor Federico Ortino at King's College London. Federico, your work scrutinizes how to save arbitration from itself, and that's a quote from your paper. So Federico takes as his baseline that investment treaty arbitration exists, but requires closer scrutiny. The object of study in reading your paper for me was the doctrine of legitimate expectations, and many in our audience are well aware most early generation treaties do not even reference the idea of investors' legitimate expectations within the investment treaty's core protections. So Fede, let me begin with you and ask you a few questions. Why do investment tribunals consider investors' legitimate expectations without any treaty text referencing for this? And how does this intrude on states' sovereign discretion to govern in the public interest?
Thank you, Mona, for that introduction. And yeah, that is clearly one of the key questions. But let me take a step back, if I can take a couple of minutes maybe to introduce. I mean, the way I see it, at least when you look at sort of more technical legal issues that surround the way that legitimate expectation has played a role as part of fair and equitable treatment, I mean, I see 3 important issues. And one, you just referred to it, what is the source of the concept being applied as part of fair and equal treatment? Now, there's a second question, which is perhaps more technical. Once you've accepted that the doctrine exists, you then ask, where does the expectation come from, and particularly whether the expectation is legitimate. I mean, I think this is the area where perhaps tribunals have, over the last 15, 20 years, sort of paid more attention to it and have sort of developed, to some extent, their understanding of what is required to find the existence of a legitimate expectation. Now, from my point of view, this is sort of part of my ongoing research. I don't think we're there quite yet, but certainly this is the area that has been looked at most closely. Now, the third technical legal issue, which I sort of focus particularly in the paper I've submitted for the Society conference, is the further question about even if one finds a legitimate expectation because of a specific representation provided by the host state, I think the further question is whether there exists an overriding public interest that would justify the frustration of that legitimate expectation. This is, and this is sort of what the paper is about. The paper basically argues that in most cases, particularly recently, this aspect is many times totally disregarded. And when it's taken into account, it sort of leads to sometimes quite strict balancing exercise, which is sort of another aspect of the public interest perspective. Now, I may come back to the later two point, but let me go back to your question and sort of why do investment treaty tribunals look at legitimate expectation when there's no reference to it? In fact, one struggles to find a reference to it even in the very sort of in the history of how treaty have developed, at least with regard to FET. But we can sort of maybe you can give us your 2 cents, Mona, on that point. The answer here is I don't really know. I mean, I can tell you what tribunals have done, and in the most part, they've just relied on other earlier decisions that have based their decision on the existence of legitimate expectation as part of the FET. Now, of course, there are here and there some tribunals, whether dissenting arbitrators, that have looked at general principles, that have looked at domestic laws, but for the most part, there's very little elaboration of how the doctrine made it into FET in treaty. Now, the surprising thing about this, and this is something that Nicolas Perrone, Professor Perrone, mentioned yesterday in the plenum, that there is quite amazingly, to some extent, consistency from investment treaty tribunals on relying on legitimate expectation of part of FET. Now, and perhaps the most surprising thing, and maybe the reason why tribunals do that, is that parties, investors, but most of all host states, have given up on arguing the opposite. So the standard point of departure is that legitimate expectation, the protection of the investors, is part of the fair and equal treatment standard, period. So from a from a perspective of looking at where does the concept comes from, I think the horse have left the barn, and this is why in the paper I mostly focus on the other two issues, particularly the third one, which are to some extent more important once we have accepted that the principle exists. Back to you.
Thank you. I was just turning my mute off. Thank you so much, Federico. And I, it's interesting to hear you say, look, inevitably the investors won. They pushed for this doctrine to be forward, and now the host states have accepted it. And hopefully we'll get into a little bit of that, of how that tension exists now when we talk to Carolyn. So one of the things I found really interesting in reading all of the papers in advance is to consider how we take for granted the language of rights to characterize investors' entitlements. Even within Fede's paper, he quotes from Professor Von Lowe as speaking to the rights that an investor has. So to unpack this, Carolyn proposes to take Hohfeldt as a platform to exploit the cracks that are there in the system. Carolyn, what can investment law scholars learn from Hohfeldt as to how to understand the nature of investor rights? Thank you.
Thanks, Mona. Well, I want to make the point that, first of all, investment tribunals frequently use the language of rights to characterize foreign investors' entitlements under investment treaties. And they do so despite the fact that investment treaties don't use the language of rights at all, which leads me to question, well, why has the language of rights been so pervasively used by tribunals? And I don't have an answer to that, but it seems that tribunals have proceeded on the basis of some kind of implicit assumption that investors' entitlements under investment treaties correlate to some form of rights, and probably property rights, but without any further explanation. So what I try and do in my paper is try and look at the work of Hohfeld for assistance in understanding what the nature of investor entitlements should be. And as Hohfeld observed back in 1913, people tend to use the word rights indiscriminately when they're actually referring to what in a given case might be a liberty, a power, or an immunity rather than a right in the strictest sense. Now I'm going to attempt again to share my slides. This may not work. Can you see anything? No? Okay, it's not working. All right, so what Hohfeld said was he divided up legal entitlements into 4 different categories: rights, liberties, powers, and immunities. Now, only in relation to the category of rights is there a corresponding duty on the part of somebody else to require that a person, a duty to observe the right in the sense of do or not do a given act. It's kind of hard to describe it without my handy slide, but I'll try and keep going. So the argument that I make for anyone who's familiar with Hohfeld is that investor entitlements should not be characterized as rights, but rather should be characterized as immunities against certain forms of government action with a corresponding disability imposed on host states. But the question is, well, why does it matter if it's an immunity or a right? What's the real difference? And I think the point that I'm trying to make in this paper is that once a particular interest is characterized as a right, its normative significance increases and the state's political capacity to regulate that interest is significantly diminished. And this goes back to thinking about the nature of rights, which many people would regard as absolute or inviolable in nature. And so characterizing investor entitlements as rights suggests that there's no room for public welfare regulation that happens to impact on foreign investment. Whereas characterizing investor entitlements as immunities suggests that we can draw some boundaries on when an investor can be immune from government action. So if we take the example of legitimate expectations, viewing investment protections as giving rise to immunities suggests that an investor is only immune from having their legitimate expectations departed from where the state's made a clear representation to the investor, as Federico mentioned, and also where the balance of interests suggests that the state has acted arbitrarily. So in this frame, legitimate expectations aren't protected in an absolute sense, but rather where the competing balance of public and private interests lean in favor of protection of legitimate expectations. So that's just an example of how it works in a given case. Mona.
Thanks. So Mavluda, let me turn to you now. Both Federico and Caro have sought to address concerns with the substantive protections offered within the investment treaty regime, and both offer insights into our future engagement with investment treaty arbitration. So your proposal really goes to what major discussions of international investment law reform are missing. And your object of study is a more inclusive rules framework to critique the unfair distributional effects of foreign investment. So a more inclusive and sustainable allocation of benefits and responsibilities of foreign investments, looking at the obligations, particular of foreign investors. So if the goal of investment treaties is to maximize the positive contribution of foreign investment for the host state, do we need investor obligations? Over to you.
Hello, everyone. And yes, so if we put it as this question, do we need investor obligations? Then yes, we very much do. I must say the subject for this paper is something that I am still working on. So it's not a finished argument. Some of it has been captured in a chapter for the book. Myself and my colleague from National University of Singapore, Jin Ho, edited recently Investors International Law, and that's the book that came out in hard publishing very recently in Federico's series on international investment law. And that's where we started exploring this idea of investor accountability in general. And what we wanted to do is to look at this space between helpless description on one hand and a ruthless iconoclasm on the other. It's the space where we could do something with the regime that we have at the moment, something that would address some of the very profound concerns about it. And so my chapter looks into obligations to do good. And in that sense, what I do, I juxtapose those obligations to the current focus on investor obligations in the sense of investor commitments to not cause adverse effects to societies, to communities where they operate. So this is still an ongoing project. That's why I really appreciate being on this panel this morning, because my thinking on this subject is still evolving. So the key strands of my argument are, well, if we put them briefly, is that foreign investment protections are meaningful only when foreign investment can have meaningful benefits for the societies that host those foreign investment projects. So, and for that reason, we need foreign investor obligations to do good for the societies that host them. And what's interesting is that idea came to me when I was working on my previous project, when I was conducting empirical case studies to trace the impact of international investment law on developing countries. And what emerged as a common thread throughout a number of case studies is that on the ground, the key concern was not so much about investment treaties, but about investors themselves, about what investors do or do not do for host societies. And it was around the same time when I came across a paper, Greg Schaffer's paper on retooling trade for social inclusion. And while reading it, it occurred to me that trade scholars have long acknowledged that international rules governing globalized economic relations, well, they redistribute wealth, they favor some over the others, but the question of unfair distributional effects of investment are not yet being addressed in major discussions of international investment law and its ongoing reform. So it is relatively uncontested that foreign investment can have negative impact, and that's where some of the major debates on investor obligations are currently being focused. But the idea of redesigning investment governance frameworks to maximize the positive contribution which investors can bring to the societies that host them, this is something which is still missing. So there is, I argue in my paper and in the project that I plan to work on come September, is that there is both a strong political and moral case for positive obligations, for investor obligations to do good, but there is also a possibility to do so. So if I have a moment later, I'll talk about it. So in terms of the moral and political case in particular, if we look at what's happening in relation to trade, there is already growing recognition that a trade should become more inclusive. And we need something of the same in relation to investment. And there is also growing recognition in the political sphere that those who feel disadvantaged or left behind by the processes of globalized trade and investment, that they will let their discontent known in different political forms, and that will spill out into various forms of backlash against international economic order. And that in itself is already pushing various types of agenda. I mean, if you think about the UK, it's the levelling up agenda, and elsewhere in other parts of the world, it is the same. And also there's another thing that some scholars have already been highlighting, including Zoe and Jonathan Bonnici in their recent work, the fact that if we look at investment arbitration case law, there is already a very growing number of cases which emerge from those clashes between foreign investors and local communities. And those clashes are generated by that discontent, over the distributional impacts of foreign investment projects. Over to you.
Yeah, so that was Zoe Williams and Jonathan Bonnici who have or did that work on the political aspects. I just wanted to make sure that her name was there. Yeah, I think you and I are very aligned in this, and something, the book that I'm writing about right now is actually telling that story in the earlier pre-BIT era of how that tension between the desires to achieve economic development and what that meant, and the initial inertia for investment protections of rights, just to go further for Caro, really came together, and the clash of that from the different stakeholders and actors that were involved, and how, for me, much of that manifests within the particular concept of fair and equitable treatment, where there you see the shift in what between the states and what the corporate interests and foreign investors desired. And really, if you sort of see now that trajectory of the history up to current day, with the expansion of what fair and equitable treatment has become, there you can really see this sort of coming back to Federico's point of the investors quite successfully shifting the system to one that is so focused on investment protection without any of the corresponding balancing or attention to actually development on the ground and what that would actually look like if those treaties were calibrated to economic development, or actually now, because of where we are in our times, to a sustainable development concept, not just simply economic. So having thought of that and tying back to this expansion, particularly of the one investment treaty protection that today, I will dispute this, but today is seen as gap filling, which was this fair and equitable treatment obligation that was supposed to complement commitments to against arbitrary treatment and against national treatment and equality of treatment ideas. So Federico, back to you to evaluate then an investor's legitimate expectation. Do host states have to make specific representations to foreign investors? We've seen conflicting views from tribunals. And how can host states ensure that consideration then of public interest is at the root of an evaluation by a tribunal of host state conduct? And let me also say as well now to those that are online with us, after this, we can all reflect more on these discussions of our three papers as the scholars have presented them. So please do put comments and we will incorporate them in. Thanks, Federico, on to you.
Well, this is so. That's what my research, my current research is trying to do at the moment. Is trying to evaluate the way that investment treaty tribunals have applied the concept of legitimate expectation in the context of ISDS. Now, the way that I do it, I've chosen to do basically to use as a benchmark domestic law. The way that the concept of legitimate expectation has been applied and it has evolved, particularly in two settings, English law and European Union law. Now, I think, it's easy because those are the two systems that I'm more familiar with, but that's not the only reason. These are the two systems where the concept has been applied to include not just the protection of sort of procedural expectations, but also substantive expectation. I mean, there's a big jump between procedural and substantive. And in ISDS, it includes particularly substantive expectations. And this is why they use the comparison. In many other legal systems, domestic legal systems, the concept is only limited to procedural expectations, which is in a sense, a much inferior weapon against the exercise of public authority. So that's my choice. And basically, I try to look at the way that the concept has developed. And this is quite a recent development, not just because the EU didn't exist a few decades ago, but also in English law, it's a recent concept, which was, sort of solidified in the last 20 years, particularly the substantive expectation bit. And basically, I compare, and unsurprisingly, you will see many of the issues that we are confronted, that the tribunals or disputing parties are confronted in the ISDS field, are pretty much, you find them also reflected in the application of the concept in domestic courts. Now, yes, so the two prong are, the first prong, as I was sort of mentioning earlier, is the existence of a legitimate expectation. And that itself is where also at the domestic level, most of the battle takes place. And in fact, this is unfortunately where, well, unfortunately, depending on the perspective, where the claim brought by an applicant that her or his expectation have been frustrated sort of loses, partly because the requirement to demonstrate the existence of a legitimate expectation is quite strict, and so not only one has to require a specific, precise, unambiguous, unqualified representations from the public authority, but it also includes an examination of whether the frustration of the expectation was not foreseen, or the measure that ends up frustrating the expectation was not foreseen by a prudent, discriminating, and well-informed individual or trader. And there are, under some exceptional circumstances, a general representation may be used as a basis to demonstrate the existence of a legitimate expectation in areas of where there's a policy change. But even there needs to be a pressing and focused assurance from the public authority or a consistent practice. I mean, this area is where things becomes a little bit gray, and I would need to do a bit more work on this part. But where the paper focuses its attention is on the very last. Let's assume the tribunal, the court, finds that there is indeed a legitimate expectation. There's a specific representation made to, let's say, an investor in our context. It was precise, was unambiguous, it was clear, it could not be foreseen. Now, and this is sort of the second step where at the domestic level, courts will ask then whether the legitimate expectation should be protected. And this is where the public interest comes up. And sort of the focus now switches on the actual merit of the measure that allegedly has frustrated legitimate expectation, and asks whether there is an overriding public interest that justifies the frustration of that expectation. And unfortunately, this is again something that is clearly missing in the investment treaty context. And in the paper, I try to sort of look at whether this is simply a matter of tribunals or disputing parties not being aware of sort of the full extent of the doctrine as it's been applied in the domestic context. And in fact, this isn't the case because I sort of highlight early on, sort of in the sort of 2005, 2006, this is sort of early days of investment treaty practice for those of you that were around back then. It was quite clear, and this was clear in the famous dissenting opinion of Professor Velde in Thunderbird. It was laid out by Snodgrass in her piece for the ICSI Review in the first edition of 2006, and then clearly put out in Saluka in the partial award in March 2006, where the tribunal exactly identifies the need to do a balancing exercise after one has decided, has found the existence of a legitimate expectation. Now, despite that early recognition of the role of public interest, somehow it's sort of fiddled out. And you know, I've focused the paper. I focus on the clean energy awards of the last 5-10 years, and surprisingly, there is very little focus by tribunals on this public interest role in the application of legitimate expectation. And it's surprising because in many instances, the tribunal has actually found a violation of a frustration of the legitimate expectation, a violation of FET, but there is very little or no reference to this additional essential step in the application of legitimate expectation. And that's what the paper focuses on. Now, I'm happy to sort of, but I can stop here, and then we can talk later about sort of the implications of this.
So much, Federico. I have a couple of questions for you, but let's go through our second round, and then I will ask my questions, and I will also then help to raise the questions that are in our public chat. So Carol, let me come back to you for a minute here. You know, you were introducing Hohfeldt. I'm sorry you didn't have your slides to explain that diagram. But what can a Hohfeldian take on property rights then? Tell us about how tribunals should, for example, determine indirect expropriation claims.
Yeah, well, indirect expropriation claims are all about interference with property rights, even though the minority of tribunals actually consider property rights in their analysis. And Hohfeldt also helpfully demonstrated that property comprises a bundle of rights, liberties, power, and immunities, just like ordinary legal relations comprise. So most indirect expropriation claims involve a restriction on the investor's ability to use their property rather than their ability to exclude others from the property or dispose of the property. Hohfeldt as a liberty of use, and so I follow that view. Importantly for our scheme of legal relations, liberties such as the liberty to use property are actually quite a weak legal entitlement because they don't correlate with a duty to refrain from engaging in conduct that would go against that liberty. So relevantly, the state has got no duty to refrain from preventing the investor from using their property, and is therefore not prevented from regulating in a manner that is meant to be conducive to public welfare. In fact, we can say that the host state actually has a Hohfeldian power to regulate through the exercise of police powers. It has the power to effect a change in legal relations affecting an investor. So again, I think what Hohfeldt helps us to do is we can see that there are different consequences attached to the different ways in which we characterize things that would ordinarily be called rights. Depending on the way in which a legal relationship is structured, the consequences are actually quite different. And importantly for our purposes, the host state's ability to regulate to promote public welfare is much better protected if we understand the true nature of investor rights as something actually quite different. And so the draft paper goes into more detail about how this all fits together, and I'm happy to email it to anyone who would like to comment on it. So please do drop me a line. Mona, I'll just leave it there. Come back to you.
Much. Okay, we're getting a couple of questions for Federico, but before that, Mavluda, and I'll read to you the one by Jonathan Benicia after I ask my own question, so you'll have both of them, and then we'll start going through the questions that are posed from the audience as well. So Mavluda, you introduced this idea about your project, and I recognize that you said it was evolving. So, you know, do we need investor obligations to do good, as you say, to be incorporated into investment treaties, or should we leave this to host states and national legislation? And I think that was my question for you. And I think, you know, to pull in, sorry, we just had a rush here, to pull in Jonathan Benicia's question, you know, he's convinced by the moral and political case for obligations on foreign investors to do good, but he's curious to hear more from you about how this would be operationalized in practice. And I think that does go to what my question was for you as well. How would obligations articulated in international instruments be linked to actually on the ground investment governance? And do you have any thoughts on how oversight and enforcement would work? One example I would say from Nicolas Perron, who spoke yesterday in his own work, talks about a participatory relational model where the investors are really consistently working with the state and the host community as one of those options, I think. But I want to hear from you. So go ahead.
Thank you. So this is something, this is actually a really good set of questions. And again, my thinking on this is still evolving. What I have thought so far on this issue as to whether this needs to be left to states and to national legislation, it's both yes and no. So investment treaties are only one part of this bigger jigsaw puzzle. And if we were to introduce meaningful investor obligations to do good, then we really need to look at them as part of this bigger and broader and more comprehensive investment governance framework. And one particular strand of the argument that we need to address before we go into those, solutions, how we operationalize all of that, is that there is a lot of skepticism at the moment as to the whole viability of introducing investor obligations to do good. And there's just, in general, a lot of skepticism as to whether investment obligations could be introduced into investment treaties and other broader rules governing investment. So this skepticism seems to be premised on a number of things. One is that the futility of it, given the sheer power wielded by multinational corporations, it'd be impossible to wield them and to make them commit to do good to host communities. Another set of another set of skepticism is usually, it's impossible because policymakers are going to be skeptical towards any innovations. And then ultimately we also see a lot of arguments when they say, look, you shouldn't introduce new things into treaties all the time because it will dilute their original mission and it will also load too much into them. But this whole idea of let's just drop this project and let's drop this these efforts because it's all futile and not feasible, it's not quite true, because if, again, as you said, Mona, if you look back at the history and if you look back at what would count pre-BIT history or pre-investment arbitration history, 1970s, the new international economic order times, it was an era where significant and profound transformations were taking place, despite the fact that corporations exercised inordinate control over territories and natural resources in the global south. Some very significant strides were made during that period to renegotiate those relations between corporations and host communities and host societies, host states, in particular in the global south. And those changes, of course, sometimes came at a cost. They were not always successful. However, they left their lasting impact on the field, as we can see. So those neo-era experiments are a really good example of what is actually possible. Then there is another. There are other things which also point to the feasibility of including investor obligations into this wider governance framework. and that is what investors themselves are doing on the ground. So again, if we step beyond the investment treaty law and its narrow confines, then we can see that businesses increasingly understand that in some circumstances, they actually really need to engage with host communities. They really need to obtain that social license to operate. And there are even legal arrangements that are proliferating to that effect. For example, benefit sharing agreements that are negotiated and signed directly between investors and local communities. And again, those arrangements are not without their flaws. They sometimes are characterized by significant asymmetry, there are issues of enforceability and so on. But again, they are precedents. They are something which show that change is possible, but also that businesses increasingly understand that having a more positive relationship with local communities is actually something that is needed for the success of an enterprise. And this is something which is very often missed in these discussions when we concentrate only on investment treaty law. And very quickly, what can we do? So I think that it is important to look beyond investment treaties. I really think it's important to look at various contractual arrangements, at national legislation, and how to make it enforceable, how to rebalance those relations between what Nicholas Peroni suggested, sort of the tripartite relationship. So it's not just the relationship between foreign investors and host states, but it's the relationship between state investors and local communities. But I also think that investment treaties, of course, have a role to play. And in that sense, we need to think not just about including, for example, incorporating clauses which say, oh, investors owe this and that to host communities. It's also looking at the wider fabric of investment treaty texts and considering, for example, their prohibition on performance requirements, which is something which actually goes against the grain of the whole idea that investors must have certain commitments towards local communities, for example, obligation to provide certain training, local employment, use local resources and other things. So increasingly we see some of that emerging in different discourse on industrial policy and international economic law. And in that sense, those obligations that I need to look at, we don't just merely need a clause that will say investors need to do X, Y, and Z. It's the performance requirements obligations, and it's other things, and it also actually goes to other provisions that we've all been talking about, including Federico's paper on legitimate expectations, because that too will be of relevance. How we interpret and apply the fair and equitable treatment standard will be of tremendous relevance to adjudicating those cases which emerge from a disagreement between investors and local communities and host states. So it's the wider governance frameworks that we need to look at when we talk about investor obligations to do good.
Thanks so much. So as a Canadian, I can say that, the recent Canadian investment treaty model from 2021, I don't think any of them are watching right now because it's too early in the morning, but it's interesting that you say that because there was a discussion on Twitter. God, I know I shouldn't bring Twitter up, but, and Federico and I engaged a little bit on this question because one of the strategies you saw from the investment treaty model, for those that haven't looked at it, was that rather than, for example, incorporating exceptions, they took this view that they were going to view all of the treaty and seek to incorporate, now we can criticize this separately, the right to regulate type of language throughout the whole thing. So they said, no, we're not going to just have investment exceptions that talk about public interest or legitimate policy objectives. It's going to be sprinkled like salt. We're going to just season the whole thing. So Federico, one of the questions I had for you as you were talking is, particularly if we do have that trade view in our head of how it works, where we would focus on public interest within the exception model, how do we put that in? And I'm going to also read from Caleb, who said, I really enjoyed reading your draft chapter, Federico. I wonder what you think are the prospects for current arbitral constructions of legitimate expectations to survive, considering all of the new states' reformulations or elimination, I would say, but he says replacement of fair and equitable treatment provisions. So you see, for example, more and more states are actually removing the language of fair and equitable treatment. Maybe they'll retain a minimum standard of treatment, or they'll do this, CETA exhaustive in quotes list. Given its centrality in current approaches to fair and equitable treatment, is legitimate expectations likely to become a free-floating zombie concept? And he there borrows from Paul Krugman. So Federico, a couple of points for you to think about.
The free-floating zombie, yes. I think we are, at least I am, a free-floating zombie. So you see, the problem with the regime as it is that any change, whatever dramatic, it will take years to kick in and have any impact. So, and I'm not quite sure that change is really being dramatic as we are looking at. It's been happening for the last 10 years at least, perhaps more if we start from the Canadian and US model bits of 2004. So it's been coming, but it's not that dramatic. Yes, you have some examples where FET has disappeared. There's only reference to arbitrariness. But even CETA, which tries to codify, I would say, a quite an expansive view of what is the customary minimum standard treatment in Article 8. It includes, and this is one of the first, the relevance of legitimate expectations. Now, maybe as a secondary role, maybe who knows? We shall see what that means. But I think it's a hint. Okay, I'm back. You see what may be the role of that reference there. I think so. Some days I'm pessimistic, some days I'm optimistic. I think this morning I'm optimistic, and I'm going to say that aside from any treaty reform that will take place going forward, I think the current interpretation, the current application of legitimate expectation will have to change. It cannot continue to go as it is, and here, the role is actually, of course, academics have a role to sort of show the possibility, the options, but I think it's practicing lawyers, councils, host states would have to, do a better job in bringing forward a better application of the doctrine, as it has been applied today on the basis of a couple of thousand existing treaties that still refer to FET in a very broad sense. So it's not a zombie at the moment. Maybe in a few decades, but I think aside from actual cases, I think we should also discuss. Once we have understood the specific features of legitimate expectations, how it is applied, the context in which it is applied, I think then we can have a discussion of whether that concept should actually feature in future treaties or not, and whether it should apply to only administrative decisions. Incidentally, this is another big question in English law, which sort of takes a quite robust view on protecting substantive expectations. It only applies to administrative acts. So parliamentary measures are excluded. They can only be reviewed, but only, well, it used to be under EU law, but that's gone now. So there are contextual issues that need to be taken into account. As it is applied at the moment in the context of ISDS, it is pretty broad. It covers anything, any act of the host state, parliament, executive, administrative, judicial, and it doesn't take into account essential component of the doctrine as the way it has developed in domestic law. Now, we could even have a discussion, I'm open to anything, that maybe in the context of investment law, the concept should be much broader. Forget about public interest, the balancing aspect. It could well be. I think if that is the case, and this is sort of one of the points I stress in the paper, I think there should be a much stronger discussion on why that is the case, and why such a principle should actually be applied in the way that it has been applied in most cases in ISDS. I stop here.
Thanks so much. Yeah, and it's funny because now you're sort of coming a little bit to Mavluda's point, which is saying, okay, should we not be putting some thought into the protections that we continue to perpetuate within our existing models? I see very much actually those two coming together, right? It's this idea of, and now with my historical context, but even now what you raise is the legal context, that there's a disconnect from the legal context of these legal concepts that is void, forgetting about the historical, political, or even economic context for why we have some of these protections. I see Vernathorn Vamasiri is asking a question, but it's again to Federico. So I'm going to come back to you. I will not forget you, I promise. And I'm going to go to Defina, who has a question for each of you. Oh, but then someone just asked a question and moved up. So she has a question for Federico, for Caro, and Mavluda. But Caro, I'm going to start with you just so that we go in a little bit of a rhythm here. And I'll come back to Federico and I'll ask both questions from Defina and from Vamasir. So for Caro, I was wondering how much you consider that all investor entitlements under investment treaties should be classified in the same way. For example, all our immunities under Hohfeldt. And then Mavluda, I will come back and we'll ask some of those ones. So go ahead, Caro.
Well, I think that bar direct expropriation, they should all be categorized as immunities. Now, a direct expropriation involves an interference with the right to exclude others from your property, which is fits back into the property type analysis that I was talking about before. So I think direct expropriation is in fact a right, but I think the rest of them are immunities. And thank you for pointing that out. I'll make that more clear in my paper.
Okay, so Mavluda, let me raise what Defina had, and then I'm gonna quickly. Yeah, so there's another question for you too. So maybe just for the interest of time, I'll put them. But let me say one thing that your point about performance requirements. What I found so interesting is that the current part I'm working on right now, as far as the history, is that one of the most obviously fiercest debates. This is pre-1960s, NIEO era. One of the most fierce debates at the time for the formation of investment treaty protections as we understand them today would have been on this idea of performance requirements, on free transfer of movement, on allowing this idea of having the domestic eventually prosper, such that almost in a way what you saw some of the proposals from countries was that it begins with foreign, but slowly over time, through training, through skill sharing, eventually the domestic people and infrastructure would be able to support that investment, and you would almost see a shift. And that was some of the desire of early thinking about that. So I found it interesting because certainly performance requirements were heavily rejected by the capital exporting countries then, and it still continues today to be an issue that is rejected. Let me, Defina has, for Mavluda, I was wondering whether you are seeing the God, such a long word, Defina. Operationalization, I got there, of investor obligations in or out of investment treaties, and if the first, as related to jurisdiction or substance. And then from Nasilisic Semericolu, forgive me if I mispronounced that, do investor obligations to do good also include the obligation to do no harm? I do believe you get into this in your paper, but you can talk on that. I think the enforceability of the latter is much more feasible compared to the former. Should we expect investors to do good when in most cases they can't be prevented from causing harm? And then I'll come back to Federico.
Thank you to all of those participants who raised those very interesting questions, and Mona, for your comments. So yes, in terms of how we operationalize investor obligations, there we go, I nearly got the word. I think I need to respond to all of these questions probably at the same time. So from the end, if we distinguish obligation not to do harm and obligations to do good, yes, they will definitely need to be addressed differently, and they will require different enforceability mechanisms. And for invest obligations to do good, we need to look more at how to enable states to impose those obligations, including in their national legislation, including in their requirements as to how foreign investors need to interact with host communities. So it's going beyond the fabric of investment treaties, looking at what states are allowed to do in their domestic sphere. And investment treaties ideally shouldn't meddle with that. Rather, they should encourage states to be able to undertake those broad array of measures that would enhance the positive effects of foreign investment for host societies, for host communities. And when we talk about obligations not to do harm, then there's a slightly different set of issues there, and enforcing those will probably have to be done in what is currently being discussed, so counterclaims and so on and so forth. In terms of jurisdiction, Adafina, your question, that's again, as I said, I look at the moment, and it's very much evolving thinking, and I do hope to spend more time on this next year. It's more about looking not just at investment treaties, but at that wider investment governance frameworks. And in investment treaties, there will not be seen, at least as I can see it now, as the major instruments to enforce those obligations. I see investment treaties as something that shouldn't stand in the way of those obligations and encourage states to do something on that front. And Mona, on your question, on your comment about performance requirements, yes, that's a very interesting development, in the sense that if you look at bilateral investment treaties of some major capital exporting countries as well, until recently they didn't feature any prohibitions on performance requirements. Look at the UK model, UK template that has been used ever since 1970s. Up until recently, no prohibition on performance requirements there at all. But at the same time, we see a proliferation of those set of the kind of policies in national industrial policies. And that's where this question again emerges as to how we reconcile them with the growing uptake of performance requirements in the more recent contemporary investment chapters and bilateral investment treaties. Back to you.
Yeah, I mean, I think it's going to be a challenge, I think, because you have that tension in, this is something I think about with my own work as well, of wanting to acknowledge the fact that states are both on the offensive and defensive. If I can take a line, I think Lauja once said to me, Pinchis-Paulsen, about that, of the interests of states. And so then bringing in the investors as well, it's an interesting idea. Let me go now to Vernathorn Vemasiri, to Federico, and there's another comment, so I'll include both of them for you, Fede. So he looks at the 1979 Penn Central case, and this is something Amon Levy brought up earlier about U.S. regulatory takings as a model. And in looking at that history of how legitimate expectations developed through the U.S. courts, his question, or their question, I'm sorry, is, of reflecting on how the Supreme Court identified specific property use and rights. They said, in the context of FET, as its content is typically not expressed and only the minimum standard of treatment is referred to, this is investment treaties, is legitimate expectations imported from, in this case, U.S. domestic courts, as well as a guiding tool of what is a more important consideration. And so here it was looking at the economic impact factor that was developed from there. The other question that I had for you, if I can just scroll down, is from Watchcheck Gizema. They say, a follow-up question to Professor Ortino, is the fact that new treaties attempt at defining the scope of the FET standard, explicitly including legitimate expectations, the final giving up and mitigation of damages, or an imperfect attempt to control tribunals' discretion in assessing FET violations? Can tribunals escape the previous jurisprudential interpretation of FET and legitimate expectations? I mean, they're not tied
yes.
to it, so.
No, but it's Warinthorn, who Sandy, she's a student at King's. Hi, Sandy. I think I don't. I mean, I think it's. I don't know. Actually, the fair question is, I don't know what's the link between the concept of investment back expectations. I think that's the technical expression in U.S. constitutional law, and the concept of legitimate expectation. I think just by looking at the context and the specific expression used, I see a stronger link with sort of the more Germanic European concept of legitimate expectation. But honestly, I don't know. Wojciech, I think that's this is sort of you brought me back to my more pessimistic mood now, and I think it touches on a crucial point, because so much of what investment treaty law is, which is sort of focuses a lot on it relies on past decisions, past precedents with a small p, that any decision, once it's been sort of rendered and it's there, it's public, will never go away. And you can see it today. Some of the early decisions that took certain interpretation of concept like FET, really a little bit too simplistic, to put it mildly, are still being referred to by the disputing parties, unavoidably, but more worryingly by tribunals. And so I think this is where I think the quote that Mona picked from the paper, which is not clearly my quote, can arbitration save itself, or save from itself? I think it's something that Toby Landau said about 10 years ago. And in his view, that was a question. It was still open. I think in my paper, if I remember correctly, I take a bit more pessimistic view, thinking that maybe arbitration can't save itself any longer, or the time has really run out. So yes, I completely agree. That is a worrying component. The amount of decisions, particularly recent one in the last 5 years, long one provided by very illustrious arbitrators, are there, and you can't simply wipe them out unless you expressly do so in a treaty.
He apologizes for this pessimism. So let me get back to Caroline here. Let me say, so completely agree, Federico. Okay. So let me get back to Caroline. Let me say also to those of you that have expressed an interest in reading Caroline's FAB paper, it will, and Caroline can shake her head if this is not right, the SIEL universe is going to post these draft papers, so you'll have access to them. So if so you don't have to put your email address. I think it'll be available to you to download. But if not, if I'm wrong on that, then you have to email Caroline. So
yeah, I'm happy to email it out once I've revised it a bit further. It's not on the SIEL website.
Okay. So there you go. I was wrong, but that's fine. So Caroline, from Calum here, Musto, I wonder if you might expand a little regarding the practical consequences of applying Hohfeldian incidents. What for Hohfeld is the solution when a privately held immunity right comes into conflict with the state's power right to prescribe, administer, and enforce laws? For example, the regulatory or police power, or what I prefer to think of as the internal aspects of jurisdiction. How might this work in an indirect expropriation or a fair and equitable treatment claim, as examples?
I think that this can be fit together quite simply. We can just say that the investor is immune from certain interferences with their entitlements by the host state, but that this immunity is bounded by the host state's police powers or regulatory powers, which permit regulating the investor's entitlements. So I think there's quite a simple solution.
Let me, because you just answered that so succinctly, I'm going to put you back on the spot very quickly. And then Mavluda has a question. So also from Verna Thorn, Abba Masiri, I do have a question for Professor Henckels. If police powers are perceived as a power, in quotes, which means that investors could be liable to certain changes to their investments, are there potential conflicts with the immunity of investor protections? While if police powers were perceived as a liberty, wouldn't this better protect a state's sovereignty as it falls outside the scope of investment protections?
Yeah, I think you could equally make the argument that the state has a liberty, which is a residual type of permission to regulate in the exercise of police power, which would mean that the investor has no right to rely on investor-state dispute settlement to prevent or remedy an act done pursuant to this liberty. And I think the concept of a liberty helps to shed light on the fact that government action properly falling within a state's regulatory power is beyond the purview of state liability, which you suggest. However, I think that the better view is that the police power and regulatory powers more generally is a type of Hohfeldian power, because it more clearly explains that the host state has got the power to change the structure of the legal relationship, including the power to create rights and impose duties by altering property entitlements. So I think I have considered the various options, and I think that the best view is that the police power is a type of Hohfeldian power.
Thanks so much, Mavluda. And this is just not for Mavluda, Federico and Carolyn as well. We have time, so we can ask each other questions. Please, Mavluda, go ahead.
It occurred to me whilst listening to all the papers and questions that one common question that might arise applicable to all three papers we've heard, including mine, is this idea that arbitrators at some point are expected to change their mindset. At least in the literature on investor obligations, I came across that a number of times, where various authors argue that the solution to the lack of investor accountability is this hope that we need to place in arbitrators, and then a simple change in mindset is going to sort everything out. And the same thing definitely applies to this interpretation and application of the FET standard, including the concept of legitimate expectation. So how do we save arbitrators from themselves? Well, they just need to change their mindset. And so, and the same with, conceptualizing investment treaty provisions as rights, entitlements, or immunities. So when we talk about these different forms of reconceptualization, and and the idea of placing faith in arbitrators and their change of mindset, is it really feasible? Can we really expect arbitrators to change their mindsets? So this is the question both to Caro and Federico. So do we need to tweak treaties to change them, to provide more guidance there, or can we leave certain things to arbitrators and various incentives that exist outside the treaty text for arbitrators to render their decisions in one way rather than another? So I know it's a big sort of amorphous question, but it's that the very idea of the change of mindset that actually I find really intriguing, and in some ways I thought that all of you spoke about it a little.
Can I just add one thing, though, to that before Carolyn and Federico comment? Do we need to be focusing on the mindset of arbitrators? Because if their duty is to simply apply the facts of a particular dispute to the law, and that is their job, and they're not concerned with the greater responsibility, and we've seen varying tribunals take different positions to that, is that simply then putting the responsibility on them, when in fact it is the duty of the states negotiating the treaties, or on a contractual framework, the responsibility in the contract of the negotiation between the investor and the host state, to better align that particular country's capacity or development desires with what the foreign investment is seeking to do? Is it better then to think about what Emma Aisbett and Jonathan Benicia have proposed, where we are closer attuned to, for example, damages, right? So is it, I mean, how do we tell an investor, an arbitrator how to think? That's my skeptical 2 cents, but not.
Well, I'm all for constraining arbitral discretion through amendments to treaties or through making new treaties. And I've got a paper in GL in 2016 about this move towards greater precision in investment treaties as a means of curtailing arbitral discretion. So I think it's incumbent on the treaty parties to do this because, as we know, the horses are currently running pretty wild on a number of different fronts, and I think something needs to be done by the principals, and that is the state parties. I don't know whether Federico agrees with me.
I think I agree with you, but I may have to go and answer the door. There's an important delivery which I'm expecting. Give me 1 second, I'll come back.
I'm gonna pretend I'm Federico. Yeah, I mean, I think you're right. I mean, and I think we have these dueling, you know, and Jonathan say the horses are running pretty wild. Yeah, I mean, look, I think we've got multiple challenges, right? We've got, oh, okay, now I'm getting, oh no, they're asking so many questions the same over. Okay, Nefela Duma, you can, I see your question. I will ask it. So we have to deal with existing treaties that have a number of protections that require subsequent interpretation or amendment, right? And reining in that discretion. And then we also have the sort of next generation investment treaties and what those should look like too. I mean, does that change for you, Carolyn?
Sorry, I didn't hear the question.
Carolyn.
Sorry, I zoned out. I was looking at Jonathan's comments in the chat and having a little giggle about that.
I was just saying that we've got dueling challenges here where we have to deal with the subsequent interpretation or amendment of existing treaties, right? I forget, I think it was Defina who posted this on Twitter that from the past year, most of the investment treaty arbitrations were from treaties, from the first generation treaties, or the disputes emerged due to first generation treaties. And Defina can tell me if I'm wrong on that. That was from UNCTAD's work. Yep, every year. So there we go. So we've got that problem. And then we have more forward-looking concerns with Mavluda of saying, if we were to reimagine the system, what would it look like? So your answer was really about subsequent interpretation, reining in the discretion. Federico's back, so I'm done stalling. But do we have to do both?
Sorry.
And then I'll get to Nefeli's question.
I just moved in 100 kilos of mortar. Good.
You're building. Are you building a new investment system?
It's things you do on a lockdown. So the question is important. The arbitrator's mindset. So I think it is possible. It is possible, and we've seen it happen. Now, it didn't happen on its own. So we've seen it, for example, with expropriation. The changes that were introduced from those model BITs I referred to from 2004, that gradually that understanding of what is an indirect expropriation sort of felt, sort of has was incorporated in the subsequent jurisprudence, even if tribunals were not applying those reform treaties. So it can happen, but on FET front, it's not happening. I think it's not. The new treaties don't really clarify what FET stands for. I mean, in one way, I mean, you could say maybe they do by just eliminating it. But that doesn't help existing treaties that still have FET, right? So this is what was ingenious of those model BITs in the 2004, is that they kept the same definition of the treaty, just added a clarification of it. So that's how they influenced subsequent tribunals applying different treaties but had the same formulation. Now with FET, that's not happening. I'm happy with Canada's latest approach, right? I mean, in the sense of at least the approach. Forget about exceptions. I mean, I think, yes, you can have them, but you should not rely on general exception. I think you should clarify what are the obligations. Clarify what is fair and equitable treatment. And this is sort of perhaps my underlying problem with the way that FET has been interpreted. It has been interpreted in a way that contradicts its fundamental nature, which is, as I describe in my book, a reasonableness-based standard. What does that mean? It means that you have to look, you cannot avoid looking at the merit of the measure you are analyzing. And so this involves, the public interest aspect of it. Anything that does not do that, in my view, it sort of goes against its principle. Now, this is my own view, but clearly, if you read any investment treaties, you don't really get that. So I think this is what policymakers should do. If they still think, that some sort of reasonableness standard should be included, they should clarify what that means much better than what they are currently doing. Thanks.
Yeah, I mean, and Carolyn sort of wrote one of the key pieces on general exceptions, and I'm glad to see you not there, that it's not just about general exceptions. What's interesting from this whole debate, we've got 15 minutes left, is that none of us have talked about UNCITRAL's efforts to change substantively the investment treaty regime through attention to the process of investment treaty arbitration. Even Mavluda's question of a mindset of arbitrators is not necessarily what they're envisioning when, for example, they talk about a code of conduct, right? And the double hatting issue situation. Because what we're really getting at is this sort of knowledge of on the ground, and how do you bring that up, right? Of reform from under, from the ground up kind of view. So, one of the questions that came in fast and strong was, okay, how do we see investment protection playing out in the UK moving forward? Now, we don't have to talk about the UK. We can talk about any country. I mean, with all of our theoretical and practical analysis here, what if you were to say one thing to a government? And I know that it depends on whether it's capital exporting or capital importing, but let's say as a base level of explaining investment treaty protection, what is the one thing that you would say? Maybe that's too much of a question. I don't know, but we'll take it from there. Is it focusing on is ISDS a red herring for focusing on this stuff? What do you think? I'm just asking now off the top of my head. You don't have to answer.
I don't know. I want to pick up on your earlier point about the court.
Yeah. Okay.
And I think there potentially is a connection there. So
okay.
Even if you keep the treaties as they are now,
yeah,
but you basically identify who the arbitrators are,
yeah,
up front, I think you can influence the mindset, right? Because at the moment, you don't know who's going to be the arbitrator.
No.
I mean, it could be anybody. It could be many of the same people that we already know, but it could be somebody new. So you don't really control that much the composition of the tribunal. Whereas with the court, I think that's the whole point, or at least one of the many points, I guess, is that you do have a big influence. States have an influence, particularly in selecting who's going to sit as an arbitrator on the court. Now, that doesn't guarantee you much. I think that's just a component. I'm not quite sure that would be, whether that should be, the key component or the key benefit of having a tribunal, but certainly is one of them. I think the most important one is what I mentioned, is that there should be clarification of what the standards are, what the obligations are.
Anyone else? Carolyn?
Well, I would echo Federico in the sense that I think clarification of what the obligations do and don't entail is absolutely crucial. I'm a bit of a skeptic about whether or not general exceptions should be included in investment treaties. My view is that if the obligations are specified in concrete enough terms, that we wouldn't have a need for those.
Yeah, that was exactly the Canadian perspective actually recently as well. Mavluda?
I agree with that in the sense that, I mean, general exceptions are not a panacea, and there's, I prefer the same, well, Canadian approach in the sense that there should be more clarification as to what various standards mean. Although even at that, I wonder if, well, arbitral tribunals then will still have a certain degree of discretion as to how to apply those. So there was a lot of praise to CETA style clarification as to what FET means, and stuff. Oh, look, it's only covering the most egregious forms of conduct, but then what's most egregious will be perceived differently by different panels. And and in that sense, again, yeah, we have that problem of arbitrators and mindsets, and what is that is likely to change it and incentivize them and encourage them to think differently. And what comes to mind is sort of tweaks in treaty formulations in various margins. I think I was looking at CPTPP recently, and I've noticed that there is a limitation as to the scope of arbitral jurisdiction over various issues. So say in financial services, if it's investment in financial services, there will have to be a panel, a state-to-state panel deciding on that first, and then it will be referred to arbitration or something along those lines. So, and I can see that it's delimiting arbitral powers in that way that might in some way actually start causing certain shifts in arbitrator behavior. But again, that in itself is not sort of the ultimate panacea or solution. And I really like the comment there that Dafina left in terms of non-disputing party submissions. I'm loving it, especially Canada and the US, making those submissions on what FET means, you know, the customary standards on denial of justice, exceptions. And this is a really interesting trend. And it's, yeah, I'm intrigued. I can't say even more than that, but I'm utterly intrigued, and I wonder what the long-term effect of those non-disputing party submissions is going to be on the field. But ultimately, it's so interesting that we see these various influences coming from various angles. It's not just this process of reform in the answer trial, you know, looking at the substance, looking a little bit and on procedure, or mostly on procedure. It's also what state parties are doing in the background, including not in the investment chapters themselves, but somewhere in other parts of their FTAs or bilateral investment treaties, but also it's how are they behaving in investor arbitration, what kind of additional forms of influence they're trying to exert. And that is really fascinating, but again, difficult to see what it's going to precipitate in terms of changes longer term.
Yeah, I think, you know, Dafina's point, and I would ask then, you know, the other, so non-disputing party, something Anthea Roberts wrote about years ago, I think it's 2015, if my mind serves me correct, where she talked about the triple hat role of states when they're not only acting as respondents, but also when they're acting as non-disputing state parties. The one thing missing, of course, from that is what do you do with non-disputing parties? So removing the state factor, and how do you address something that CCSI and IAED have been petitioning for in UNCITRAL trial, which is the role of non-state actors' involvement in being able to participate in specific disputes. What would that look like? That's a whole thorny other issue, I think, but it does get somewhat to the heart of your concerns, Mavluda, of that baseline responsibility of investors and the community particularly affected on the ground. Then whose voice is that? And what happens when the local community's interests are not necessarily aligned with the host state, right? And how are they addressed, I think, is another important piece of that. Calum asks about interpretive statements and reining in FET. And it's funny, you know, I mean, so Federico and I have been talking about this for almost a decade now, of the fact that part of the book that I'm trying to write is talking about this early iteration of FET, which had so little to do with substantive protections and how it grew into that. And a lot of his desire to tie it to a reasonable standard is one where, in the context outside of ISDS, outside of investment treaty arbitration, the governments would have used a concept or a general principle like fair and equitable treatment to plan for what investment protection could look like. And in that sense, that guiding principle was there to encourage further debate. And how it grew into a substantive protection and who asked it to be a substantive protection. So taking the same language, switching the grammar of using that in a different structure. And then of course you have this pivot with investment treaty arbitration, substantively changing it. That I see very much, Federico, in what you were saying. What do you all think of joint interpretive statements? It's from Calum. How likely is this to affect meaningful change? What are the practice and how could these be overcome? Any comments?
And
Yeah.
I think I prefer the joint statement than a statement from the non-disputing party. I mean, I think it clearly has a stronger value, at least in the context of that specific treaty. I mean, we've seen that in the context of NAFTA, sort of where that was early on used. Now, I mean, I think that context also shows you that depending on the content and the clarity of that statement, tribunals will maintain a certain margin of discretion. So it's all, but I think it's as I think as Caroline mentioned, everything helps. Or maybe it was Mavluda. I mean, everything contributes, right? So certainly involvement from states and non-state parties, whether within an arbitration or not, will have an impact eventually, hopefully.
Mavluda, Carolyn, you have the floor for your final comments, thoughts, please.
On that particular issue, I'll defer to Federico.
Any final comments otherwise?
I did see another question in the chat, which seemed to be an interesting one. I don't know if you're going to address that.
Which one?
From Afiwan King.
Oh, I'm sorry, yes. So several of you have advocated for the reformulation of the substantive provisions in investment treaties to incorporate public interest-like considerations rather than relying on general exceptions. Yes, I think we all agreed on that. How would you foresee this working in the context of treaties where trade and investment chapters, where there are typically general exception provisions model off the GATT? Would you advocate for totally separate legal regimes or similarly clarify the trade? I mean, so the easy answer to that is you simply say the general exceptions don't apply to the investment chapter. What were you going to say, Carolyn?
I think we should clarify the trade obligations as well. Like if you look, for example, at national treatment, in the WTO context, those public policy considerations aren't taken into account at all when determining whether or not national treatment has been complied with, whereas investment tribunals have actually done a pretty nuanced analysis of the role of the measures, purpose, and its tailoring. So I think, and they've done that largely in a system without general exceptions. General exceptions are a relatively recent development in international investment law. So I think that's one of the few situations where trade can actually learn from investment law. And it strikes me that if the provisions of the GATT were clarified, there would be no need for public policy exceptions. And the same goes for various other provisions of GATT where the exceptions currently play a role.
Yeah, and in fact, Tim Meyer and Todd Tucker, in their recent proposal for a carbon border tariff, are observant of the that issue of the fact that there is no assessment of public policy within national treatment. So they align with that there. Mavluda, did you have any comment?
This is the question where I feel very much undecided, in the sense that I'd like to see a public policy exceptions personally applicable to investment chapters in the same way as they apply to trade chapters. But on the other hand, I understand that even at that, they might have their limitations because, again, if we go back to the question of arbitrators' mindset, and if we look at cases, I don't know, Bear Creek and some others, we can see that even general exceptions might not necessarily save certain disputed governmental measures if tribunals are prepared to condemn them. So to what extent extending general exceptions to investment chapters is going to be ultimately useful it's still out there. The question, the jury's out on that. And then the solution seems to be in, again, doing that wholesale tweaking of the entire investment treaty text or investment chapter text, as well as other provisions within an FTA or bilateral investment treaty, and then also looking outside those treaty texts for various other mechanisms, incentives, legal arrangements that contribute to this overall overarching investment governance framework. So, and that's, I suppose it's not particularly comforting question if you are thinking about that clarity and, you know, certainty of vision.
We are out of time. 1 minute left, Federico. I don't know if you have any final comments. Carolyn,
No,
Mavluda?
I think we should give away to whatever comes next.
Yeah. Okay, so to advocate for Marcus, who put it in a couple of times, if you are interested in a networking session, it is now. There is a link in our public chat and a password for you there. If not, thank you so much to everyone for participating. Thank you to our speakers, Professor Federico Ortino, Professor Carolyn Henckels, Professor Mavluda Sattorova. Thank you so much.
Thank you, Mona. Thank you very much.
Thanks, Mona.
Thank you, Mona, and thanks everyone. Thank you.
Bye.